So you want to appeal your probate court ruling. Overturning a trial court on appeal is not so easy because the appellate court has very limited rules that it must live by. And there's 3 broad appellate standards that the appellate court will use. The first one is what we call de novo review. And that means the court actually has the freedom to decide the case anew, as if they were sitting as the trial court. The problem is de novo review only applies if it's a legal determination. So if all the court is doing is making a legal determination without any need for facts, all the facts are already agreed to between the parties, nobody's contesting any of the facts, it's merely the legal determination based on those agreed upon facts, then the appellate court can hear the case anew as if it's sitting in the trial court seat. The appellate standard that's most often used is what we call substantial evidence test. In this instance, the trial court has already made its determination, and it made that decision after hearing evidence. So it heard testimony from witnesses, it reviewed documents, it considered legal arguments and oral arguments in court, and then it took all of that information and it came up with a decision. And if you don't like that decision, you appeal it, but the appellate court can only overturn that decision if it determines that there was not substantial evidence to support the trial court's decision. That doesn't mean that the appellate court gets to look and weigh the evidence anew. It's not going to look at the evidence and decide the trial court was wrong here or the trial court was wrong there. Instead, the appellate court assumes that everything the trial court did, every decision it made was proper and was the right decision. It's only going to look at, was there at least enough evidence to support somebody making that decision? And as long as there's some evidence somewhere that would allow the trial court to make that decision, then the trial court decision stands and it won't be overturned on appeal. As you can imagine, in almost every case, there certainly is at least some evidence on both sides of a case. And so there almost always is at least substantial evidence to help support a trial court's decision. You may not agree with that evidence. You may not agree with the trial court's decision. But the appellate court is not there to make those decisions at all. They're not there to say whether the trial court was right or wrong. They're not there to rejudge the evidence for themselves. They're just there to say, did the trial court have some basis to make this ruling? And if so, end of story. The last appellate standard I want to talk about is abuse of discretion. So if the trial court has the discretion to decide a case, but it abuses that discretion, then the appellate court can come in and overturn that decision. Now this is somewhat important in probate court because a lot of what we do in probate court is based on the discretion of the court. Probate court is what we call a court of equity. So the judge has a lot of leeway in a lot of cases and a lot of determinations to decide who's right and who's wrong and what the ultimate damages are going to be or the remedy for that wrong is going to be. But if they go too far, if they abuse that discretion, then the appellate court can step in and overturn that decision if it thinks that it needs to do that. The problem with an abuse of discretion argument is it has to be pretty blatant. So you actually have to have a court exercising discretion in such a way that there is just no basis on which to exercise that discretion. And that's very rarely the case. I mean, typically when the court's exercising discretion, there's something to back it up. There's at least a little bit of evidence to support that decision. You may not agree with it, but there's enough on the record so that the appellate court is not going to say that was an abuse of discretion. But if you do have a case where the court made a ruling, exercised its discretion with no legal or factual basis to do it, now you might have grounds for an appeal under the abuse of discretion standard.